In this presentation, we are going to talk about the Constitution and powers at different levels of public health. By the end of it, we hope you can understand the role of the U.S. Constitution in setting framework for federal government, define federalism, and explain how the Constitution allocates power between federal and state governments, and explain the difference between express preemption and implied preemption, and understand the role that preemption plays in public health policy. A new public health law should be rooted in the best available evidence, but it also needs to be legally sound. The city council, legislature, or agency enacting the law must have the legal authority to do so, and the law must not exceed the limits imposed by any higher law, like the state or federal constitution. It does not matter how effective a suggested policy would be if it's struck down in court. Under our system of government, questions of legal authority, questions about who has the power to do what, ultimately track back to the national constitution. The U.S. Constitution allocates power between federal, national government, and state governments, sets limits on the government's powers, and defines the roles of the three different branches of the federal government. Drafted at the Constitutional Convention of 1787, the Constitution was designed to remedy some of the problems with the Articles of Confederation, the first compact binding of the newly independent states. Salus populi supreme lex est is actually a Latin phrase that translates to the health of the people is the highest law, or let the welfare of the people be the supreme law. It has been influential in law and politics and is often found in works of public health ethics. The phrase has been subject to debate over years. When we talk about state and local power, this is very important. States actually have the authority to protect the common good of their population. They also retain police powers. These police powers are in order to promote public good, the restriction of private interest, and also we need to add that the scope of state power is rather extensive. In the United States, police power is the authority of the state to regulate and control people and resources in the interest of public health, safety, and security. The 10th Amendment of the Constitution reserves these powers to the states, unless they are delegated to the federal government. The legislative body of each jurisdiction defines police powers, determining the public purposes that the legislation should serve. The police powers doctrine states that states have the right to regulate in the public interest and do not act wrongfully when they enact non-discriminatory, proportionate, and bona fide regulations in accordance with due process. The U.S. Supreme Court uses a balance of interest doctrine that determine whether a state has the right to exercise its police powers and has sometimes ruled in favor of the state even when federal laws take precedence. In addition to police powers, states usually remain free to govern health within, as long as they are not acting in disagreement with any federal laws. Most of the time, protection of children and incapacitated person actually falls to state rules and regulations. Federal powers of public health are limited to what is actually written explicitly in the Constitution. Federal powers are associated, however, with the authority to tax and spend, which usually makes anything that they do have more of an influence over public health. Federal power has the ability and the responsibility to promote science and also pass laws for states to follow. The Commerce Clause of the Constitution gives Congress the power to regulate commerce among states with foreign nations and Indian tribes. It also prevents states from interfering in interstate commerce. This actually leads to a limit in the state police power. There's actually a lot of times shared jurisdiction between federal, state, and local in terms of public health. And that's why it's very important that federal, state, and local entities cooperate when it comes to public health, as actions taken usually are more successful when everybody is on the same page. Constitutional limits that are set that may impact public health and their authority is the safeguarding of individual rights and freedoms. Also, the differentiation between public and private is very important when we think about this in terms of public health. Privatization of public functions. What this means is there's sometimes organizations or groups that are private that can carry out, on behalf of public health, interventions that public health may be wanting to do, or also rulemaking. Additionally, we need to consider the Jacobson decision. With this, it's expressly enunciated a framework for the protection of public welfare over individual liberties, as granted by the U.S. Constitution. Essentially, what we mean by this is that the Supreme Court held that personal liberty may be circumvented for the good of the public under state police powers. Public health is a necessity, and by this, everybody has to have reasonable means to support their health. The proportionality has to be there. With this, you need to look at equality and equity. When we think of things being distributed equally, they are given to everybody within the same amount. However, when we're talking about health and the health of people, some people may be at a lower health right now and may require more resources. So this is where equity plays a point. And that's what we're talking about, proportionality. When we think about the Constitution, we also need to consider the limitations. There are limitations what the state can do written expressly within the Constitution. There is a restriction on commercial speech, and there also is an associated compelled commercial speech. When we talk about public health, we always need to consider civil liberties. These are the individual liberties that everybody gets within the United States. Sometimes when we're talking about public health, they are complementary, but sometimes they conflict. So it's always important whenever we're writing law or when we're enforcing a regulation that we consider individual liberties, because you could be taken to court because you have taken away somebody's individual liberties, even if it is for the common good. The public health system in the United States is actually decentralized, just like the government is. And by this, I mean that there is not one governing authority for the entire nation, that states individually get to figure out how they want to govern themselves. This also applies to public health. When we talk about local health departments, they are usually governed by a board of health. It's an entity made up of subject matter experts that come together to make sure that the health department is acting within the best interest of the community. This can be governed in different ways. By this, I mean that not all states have local health departments. Sometimes they have regional health departments. Because they're more regionalized and the authority rests with the states and not the local health departments. In a completely decentralized state, it means that enforcement and rule carrying out is with the local entity, and that the state just provides guidance and support in terms of a monetary supplement. The development of state health departments actually occurred after the development of city or county health departments. So in the United States, local health departments started way before state health departments did. Most state health departments, if not all, are actually cabinet level agencies. By this, I mean that the director or the lead official within the state health department reports directly to the governor. So it's a cabinet level agency. Because of this, it is subject to being changed out or switched at will with whoever the governor is. This at times can lead to directors or state health officials that might not be qualified for public health, depending on the governor that gets elected for that state. State health departments are governed by state legislation. By this, I mean that they are given appropriations, so their funding is, even if their funding is received from a federal entity like the CDC and not state funds through taxes, they receive appropriations through state legislation. So state legislation can fund or defund a health department. Additionally, state legislation is responsible for making sure that the rules are in place for public health, and they can stop rules from moving forward or create rules where public health needs to act in a certain interest, like a Parkinson's registry. State health departments usually have the fiscal responsibility and also the program responsibility. So when we talk about this, we mean that federal entities are usually holding states responsible and they fund state health departments in order for making sure that programs for public health are complied with and followed out throughout the entire state. One of the best examples of one of the programs that State Health Department does is childhood vaccines. Most of these campaigns and programs are led by state health departments to ensure that all children within a state are vaccinated prior to going to school. Federal public health and its authority has actually expanded over time. Many agencies started in the later 1800s, leading up to the early 1900s. Roosevelt's New Deal actually started a number of these agencies to promote common good and improve welfare and the health of everybody in the United States. One of the important things to think about when we think about federal public health is a lot of them think that health should be in all policies. There's been a big ask from CDC, HRSA, and all health and human service agencies that health is considered any time that a policy is brought forth to the United States government in order for consideration. And this is the reference for this presentation.